Hey there, Louisiana estate planning attorney Paul Ramblay here, and in this video we're going to talk about what a child's rights are when their parent, who's married, lived in Louisiana, and their parent passed away without a last will and testament, also referred to as the parent died intestate, without a last will and testament. What are the children's rights? So here we'll be talking about what's called naked ownership rights. Let's jump right into it. Parent dies, parent's married. Parent who died likely has community property with their surviving spouse, may have some separate property. We'll talk about what the child's rights are, all in that. Again, I'm going to reiterate, this is when a parent dies without a will. If that parent died with a will, then the will controls who gets the assets of the deceased parent. So this is the circumstances when a parent dies without a will. And the problems often surface many years later when that surviving spouse passes away, but things need to be documented properly at the time that that parent passes away. All right, so here's the deal. We have to go through what are the rules when a married person dies without a will, and they lived in Louisiana. So there's basically two rules. If that married person had separate property, then the separate property of that married person, when that married person dies, goes straight to the children, the married person's children. So if that parent dies, he has 3 children, he's married, but if he's got some separate property, it goes straight to the children. What is separate property? Well, you almost have to determine what separate property is, you have to determine what community property is. Separate property generally is one of 3 things. It's property that a person has, could be money, could be land, an asset that a person has, and they received it one of 3 ways. I don't know if received is the right word, but if a married person received an asset by way of a gift, someone gives you $50,000 and you're married because it was a gift, that's the separate property of the married person who received it. The second category of separate property is an inheritance. A person's married. They inherited shares of stock or a piece of land or money from someone else, maybe their parents. That's the separate property of the person who inherited it. And then the third class of separate property is property that someone acquired before they get married. They acquire a home before they're married. Even after they're married, that home is still the separate property of the person who owned it prior to the marriage. So if it's one of those 3 things, a parent dies and they're married and they have assets that were given to them, were inherited by them, or they had them before the marriage, that separate property goes straight to the kids. Now, community property is assets generally acquired with their spouse. And I will tell you, the presumption is that if either spouse owns assets in their name, there's this presumption that it's community property. So the people who want or need to prove that it's the separate property of a spouse have that burden to prove that it's the separate property to overcome that presumption that everything either spouse has is community property. All right, so the separate property goes to the kids. The trickier issue is with community property. A couple gets married, they buy a house, they have some savings, they acquire some investments. Now a parent dies owning 1/2 of the community property. What happens to that deceased spouse's 1/2 interest in the community property? Well, in Louisiana, we have rules that are unlike all of the other states' rules. And the rules are, as to the deceased spouse's share of the community property, the surviving spouse inherits what's called a usufruct, a term only used in Louisiana. The surviving spouse inherits what's called a usufruct of the deceased spouse's 1/2 of the community property. And that usufruct lasts until the surviving spouse either dies or remarries, whichever occurs first. And by inheriting the usufruct, the surviving spouse is inheriting usufruct subject and in addition to the usufruct, that ownership is broken up into usufruct, and then the children, as to the deceased spouse's share of community property, those children are referred to as naked owners. They inherit the deceased spouse's 1/2 of the community property, but they inherit it subject to that surviving spouse having the usufruct of it until that surviving spouse either dies or remarries. A big mistake that many naked owners make, many children make after their parents die, is they're presented with an option, or those children are presented with paperwork, something like, yeah, you're entitled to the naked ownership, but you know what, children, why don't we just keep things simple? Why don't you donate your naked ownership interest back to that surviving spouse? And then that surviving spouse winds up consuming the asset, leaving it to other people, and the children of the first spouse to die wind up with nothing. So be careful if you're a child who is entitled to naked ownership and you're given this option or this opportunity to donate your naked ownership interest to someone else or to the surviving spouse of the deceased. Be wary of that. And then also know that the usufructuary has some responsibilities. As naked owners, you have to hold them or can hold them accountable for any losses resulting from fraud, default, or neglect over that community property. Also know that the usufructuary is responsible for ordinary maintenance and repairs on property subject to the usufruct, and the naked owners can compel the usufructuary to make the repairs for which they are responsible. So again, problems often come up much later, and they need to be addressed at the time that they need to be addressed, not after the surviving spouse passes away. So the key here is, if you have a parent pass away and you're concerned about protecting your inheritance rights, you're going to want to make sure that everything regarding that deceased parent's succession gets documented properly. Not only that you inherit your portion of the separate property, but also all of the community property gets documented well, not because you're entitled to any of it right away, but you are entitled to it when the surviving spouse dies. But if it's not documented properly at the time your parent passes away, then your rights kind of go away and you won't be entitled to exercise those naked ownership rights when that surviving spouse passes away. Okay, so a lot of stuff there, but it's unique to Louisiana. Key here is making sure that all assets get documented properly in a succession to secure the future rights that a child may have to inherit when that surviving spouse passes away. Okay, hope that helps. Y'all take care. Make sure you like, comment, subscribe, all that good stuff. We'll see you next time.